Good afternoon, friends. This is Bikram here. Actually, we just gathering here for discussing our case study right here for the related to the Northside Development Private Limited versus Registrar General. And in our group, we having a five member, the Jasmine, Mandeep, and Satgur and Koshan. And the first part will be discussed by myself, and the second part of issue and provisions will be discussed by Mandeep, and the decision part will be discussed by Satgur and Jasmine. And the last part, the facts, will be discussed by the Kaushal. In the first part, we having the facts of the case. The first of all, the Northside Development Private Limited main objective was to hold the land properties in New South Wales. It has three directors, and one of the directors, Robert, of the company, appointed his son as the company secretary on the registration of the earlier, and his appointment was not valid as it was as a per article of the company. And the Robert secured a loan worth of 1.4 million for a company controlled by Robert himself, and a loan was raised on the mortgage of a land property and owned by the Northside Development Private Limited. The director came to know about the mortgage of land when the Robert failed to repay the loan. And NDL claimed that the mortgage deed was invalid as it executed by Robert without any consent for other directors of the company or without obtaining any authorization from the company. And this is a fact of the case. And the second part will be discussed by the Mandeep. That's the issue and the provision. Mandeep, here.
And the case relates to determination of a scope and operation of doctrine of indoor management, and it also determination of extent the third parties are supposed to go behind the scene, and determination of whether the lenders were entitled to rely upon the rule of indoor management or not. And the third part is the provision of Corporation Law 2001 applicable in case. The whole case revolves around the principle of indoor management. In section 68A, the person dealing with company has no source of the way to identify any irregularity in the internal affair of the company. And the benefit of section 68 is not available to the outsider if it was clear from the nature of the transition that there is some irregularity and he did not inquire about it, and he entered into a transition with the company. And the third part will be explained by Sadhguru.
Hello. Fourth part is decision analysis. There is some decision that are related to this case. Argument put by NDL. Party which wanted to take loan was not the owner of the land property which was offered as security. Property given as security was only land property owned by the NDL. There was no benefit to NDL from the loan taken by the director. Argument put by some argument that are later put by the NDL. Loan transaction was entered by the director of NDL with the help of his son. The appointment of company secretary was invalid. That's why transaction involved in the case was not of an ordinary nature, rather it was transferring of the title of property. Therefore, lenders should have made series of investigation. Next. And some decisions that are taken by the court of law. Mortgage deed was held invalid and general registrar was held liable to compensate NDL for the loss suffered on basis of following grounds. NDL has no relation with borrowing company. There was no benefit to the NDL from the loan transaction. Extent of irregularity was clear from the nature of mortgage transaction. And last one, doctrine of indoor management was not applicable. And rest of the part will be explained by Jasmine.
Now we will discuss decision on appeal by the registered journal. Arguments put by registered journal. Third parties dealing with the company are not supposed to go behind the seal and signatures of the officers of the company with which they enter into any contract. Therefore, the principle of indoor management is applicable. And The decision on appeal by the Registered Journal. The Court of Appeals gave decision in favor of Registrar Journal, and it was held by the Barclay was not supposed to inquire into the internal management of Northside Development Private Limited. The basis of the decision was the lender was induced to make contract on the representation of authority by the officers of the company. The lender party actually replied upon the authority represented by the company officer. There was nothing in the article or memorandum of the company which deprived the directors of the entering into the contract. The principle of the estoppel was assumed, which described that when no objects to the authority of the officer of the company, the person is assumed to be the true representative of the company. And there are some arguments by NDL. NDL appealed against the decision of High Court on the ground that the rule 30 is not applicable in case of forgery. The document in relation to mortgage deed, which was supposed to be signed by the secretary of the company, was not actually secretary of the company, as his appointment was not done validly. And the next part will be discussed by Kush.
Thank you. Hi, my name is Kaushal. So I'm talking about the effects and implications of the decision.